Welcome to Winning with Annalee. I'm so glad you've joined us today. We've got very, very important topics to talk to you about. One of the things, those of you who know me, you're aware of the fact that one of the things I truly, truly believe in is working with a team, getting people who are experts in the things that I'm not an expert in. I am not a CPA. I'm not an attorney. I know enough about those things to know when I have to send you to someone who is an expert in those areas. Today I've got a good friend and colleague with me, Kathleen DeMaria. Kathleen is an estate planning attorney. She's a shareholder in the law firm of Smith, Sauer in DeMaria. She's one of the 5 practicing attorneys in the Pensacola area who's certified by the Florida Bar in wills, trust, and estates. Are you getting the idea why I like to work with this lady? She knows what she's doing. Kathleen frequently lectures on estate planning. She's authored numerous articles for the Pensacola News Journal and other publications. Just someone I highly admire. I respect her knowledge. Kathleen, welcome to Winning with Annalee.
Thank you. I'm glad to be here.
I'm so glad you're here. And what I'd love to do today, if we could, is talk about the importance of estate planning. When clients come in to see, we talk about their financial house. But too often, I think people don't realize that what you do is almost at the center of that puzzle. Everything else has to hook in to what you do. People think, oh, I can come see Annalee and I'm done. No, we need the rest of the team. So I'd like to talk about the power of estate planning. And gosh, we could talk about this for what, 5-6 days?
Probably.
Minimum.
And not be done.
And not be done. So what I'd like to do is, let's kind of start with the simplistic side, if you can call it simplistic, the will. I mean, that's something people come in and why do I need a will?
Well, you need a will if you don't want the state of Florida or wherever you live to decide what your will is for you. I have a case right now where unfortunately the client didn't see fit to get a will.
Okay.
She was a single lady. She had never been married before, never had any children. She passed away owning some property. So I get a call from one of her sisters. Her sister tells me, well, there's 3 surviving sisters. Can you help us handle everything so we can get the estate? And I said, well, are your parents alive? And she says, no, they're not. I said, okay, well then you would be heirs to your sister. I said, are there any deceased siblings? She says, yes, there's 6 deceased siblings.
6?
Uh-huh. Yep. I thought, okay, it's time for
Plus
2
3
Excedrin.
alive.
We need 2 Excedrin now.
Oh,
yes.
gosh.
And she says, why does that matter? And I said, well, each of the deceased siblings, if they have children, they're also heirs to the estate. And she says, uh-oh. And I said, why uh-oh? She goes, well, I have a niece and a nephew that are deceased too, and they have kids and they're minors.
Oh, my gosh.
So we have 30 people.
30.
30, all over the country that are going to take a part of this estate, if we can get it all together.
One piece of property.
One piece of property and 1 life insurance policy.
That's a whole bottle of Excedrin.
Yes, it really is.
That's
it
a
really
whole
is.
bottle. Wow.
Yes.
And don't you find, unfortunately, people think that it's like, oh, I don't have children. I don't have to worry about that stuff. Or I'm married, it's automatically going to go to, I don't have to worry about that stuff.
Well, unfortunately, just because you're married doesn't mean it automatically goes to your spouse. If it's jointly titled with the right of survivorship, or what they call husband and wife tenants by the entireties, then it automatically passes. But if just one of you have assets and either of you have been married before and there's kids from a previous marriage, the spouse does not take 100% in Florida.
Oh.
The surviving spouse only gets half, and the kids get half.
And the kids get half. Wow.
Now, if you're in a situation where it's your first marriage and the kids are all yours, it does all, in fact, go to the spouse if you don't have a will. But not if it's a yours, mine, his, and ours.
Wow. And that's, I know you see it very often in your firm. I see it very often in my firm. We have so many what we call the blended families.
Yes. More and more, that's what we're seeing.
More and more. You know, you had children, I had children, we get married, we have our own children. Oh, gosh, how confusing that gets. And if you're not careful, my understanding is you can actually disinherit your own children or your own grandchildren.
At least once a month, I get a phone call from a client's child. And they'll say, or usually it's not a client. Usually it's a child that just calls me and says, I just talked to my stepmom, and Dad died a while ago, and I was asking her what part of the estate I'm getting, and she told me nothing. Nothing. And the child's like, I can't believe that. Dad worked his whole life for everything you guys have, you know, he paid for. And, you know, the child says, she's not right, is she? And I'm like, well, you know, if everything was truly joint with the right of survivorship, when Dad died, automatically stepmom now owns everything.
And she can give it to her children.
Well, stepmom, if she doesn't have a will, does not have as her heir the children from the deceased spouse, unless you get down to a long list of people. So they would not be takers under her documents or under an intestate scenario for her. So if she dies without a will, her kids are going to take, not his kids. So the kid's always saying, well, when she goes, I'll get something. I'm like, no. You're not going to get anything unless you're very nice to her and she goes to an attorney and puts you in the will.
So you have to be extremely, extremely careful with that.
Yes.
The other thing that I have witnessed in my own office is older couples who have either been through divorces or spouses have died. They do decide to live together without marriage because of the Social Security laws. They want to keep the higher Social Security benefits or retirement benefits that they have had. And one of them dies. They've sold their house, poured all the money into the other one's house. One dies, and all of a sudden that person's children left with nothing.
Absolutely nothing.
Left with nothing. Wow.
Yep.
So the will basically is saying then to the court, this is what I own, and this is where I want it to go.
Correct. And you can put whatever stipulations on there that you want.
Okay. All right. So can I just go out and get on the internet and, you know, type out a will or do one on my own handwritten or go to one of the, you know, office supply stores and, you know, they got all these little things and you just pick one up?
Well, the problem with that is the handwritten will in Florida is not recognized. It would be if you had two witnesses on it, but just in your own handwriting, which is what we call a holographic will, that is not recognized in Florida.
Okay.
Unless it's got the witnesses. As far as going on to LegalZoom.com or to, you know, one of the office supply places and getting your own form, it may be better than nothing. But sometimes it is not. Early on in my career, I was involved in a probate mess of litigation, that had been going on for 17 years.
17 years?
17 years because the gentleman had drafted his own document. And he had violated certain rules. So his family was in a fight for 17 years over his estate. So was it a good idea for him to do it? No, it wasn't.
17 years, I would think a lot of his estate was eaten up by court cost and...
The winners were the attorneys.
Yeah. And I think that's the thing people forget about probate. Not only is everything public, all of your personal files, everything you've had becomes public record. I mean, anybody can go into that, can't they?
Anybody can go look at the probate files. Now, there are certain things that are sealed within the probate files, like the inventory. But frankly, anybody who knows what they're doing can look at what is available and pretty much have a good idea what size estate this person has. It's not
that
difficult.
Is scary. So the thing is, maybe we should not be penny wise and pound foolish, which is what I think a lot of people do. I know, and you know who I'm talking about. You've been in my office. I say you've got to go see one of the attorneys, and I've got several that I will recommend. And one of the first things I hear is, well, how much is it going to cost? Well, that's one of the reasons I use the people I use, because I know if I send you a client, you're not going to rip them off. You're not going to give them more than they need. But very often it's best to spend that amount of money, whatever it might be, to have the assurance that your family, at a time when they should be pulling together, are not being pushed away from each other. Yes. And you've seen that.
Oh, seen it 1,000 times.
Yeah.
An appropriately drafted will help keep your family together. Now, sometimes it divides, because sometimes mom and dad get kind of cute in their documents, and they make the surviving children mad. But that's up to mom and dad. As I tell mom and dad, it is your money. Your children do not have to inherit anything in Florida. You can give it all to your favorite charity if you want to.
Yeah.
So, I mean, children don't realize that. Children think, I have a right to mom and dad's stuff. Yeah. Well, they don't.
Yeah. So at that phase, it's kind of like the Smothers Brothers, where they really know mom did love you best.
Right, right, exactly.
Not good. And it's so different, the different states, because like in Louisiana, the heirs do inherit a part of a home if the parent dies, and you have to give your parent what they call usufruct, the right to use that home. So depending on the state in which you live, make sure you get a good, competent estate attorney. Any attorney can draw up a will, basically, but you want somebody who is doing this on a daily basis. It's too important to go to the divorce attorney and say, draw up my will. Get the expert to do what needs to be done. And I know I send a lot of my clients over to Kathleen, because I know she's going to take care of them and she's going to do what needs to be done for them. Avoid the nightmares. I mean, it happened in my own family. My own family was totally split up from lack of proper estate planning, and that's why I do what I do. I've been out teaching people for 26 years so they can avoid those things. It hurts. It hurts too much to lose your family when you can keep them together by doing very simple documents. What we're going to do when we come back, we're going to go a little bit further with the will, but we're also going to talk about the powers of attorney and why those are important, especially now with the health laws that have changed, the new HIPAA laws that are out there. You don't want to be in a situation where somebody you love is in the hospital and you walk in and you're told, I can't talk to you. And that can happen in today's world. So I think right now we're going to take a short break, and then we'll be back in just a minute and continue with Kathleen DeMaria.
So, I'm kind of new here, but I've noticed a trend. My human does this funny thing where she goes around and gets all my toys, and then she hides them in that basket by the door. It's like, hello? That's where you put it last time. You were the worst at hide and go seek.
I started mentoring my mentee, Dantre, 4 years ago. I always thought about doing it.
Etienne's a very close friend. I look at him as a brother and a father figure. I would like to give back, just like Etienne gave back to me. Be someone who matters to someone who matters.
Mainstay Financial Group offers advocacy and personal financial guidance in a caring environment. That's the heart of our practice. At Mainstay, we're dedicated to exemplary service and a caring relationship with our client, not with a number. Plan for the future now with Mainstay Financial Services.
When you're finished with your food or beverage cartons, toss it in the recycling bin. Because every carton is recyclable and can be turned into useful paper products. Put your carton in the bin with your other recyclables and let them start a new life. When the contents are gone, let the carton live on. Recycle your cartons.
Welcome back to Winning with Annalee, and I want to reintroduce my guest that I have with me today, Kathleen DeMaria, who is an estate planning attorney here in Pensacola, and Kathleen and I have worked together for many years and many clients that we have seen together because both of us believe in the team approach. I need to know what she's recommending. She needs to know why I'm doing what I do. So it's all a vital part of what's going on. So, Kathleen, we've kind of talked about the will. So I go in, I sit down with you, I do the will. Am I done forever?
No. Things change, life changes, tax laws change, the Florida probate and estate laws change. So from time to time, things need to be updated. I tell my clients, any kind of major life change, a birth, a divorce, a marriage, any of those things, you need to go see the attorney. If you hear about a major tax law change, which we usually do, if there's something major, it's in the paper, that might precipitate you needing to go to an attorney to make a change.
Sure.
So no, you need to look at it, from time to time.
Sure.
I tell clients, you get out your things to do your tax return once a year, take out your estate planning documents and relook.
And look at them.
Yes.
Look at them.
You don't want to be in the situation where you've given your children to somebody you don't speak to anymore.
Hello.
And I've had clients come in and read the will and go, oh, we had a fight with them a long time ago, and we don't even speak to them. So.
Or you don't want to leave your schnauzers to somebody you don't talk to
That's
anymore.
Right.
That's
right.
Goodness gracious.
Right. You don't want to leave the babies.
Don't leave the
furry
babies
kind or the real
unprotected.
kind.
So, and we do that in the office. Every time a person comes in for a review, we double check the beneficiaries, because the importance in what I do on my side, life insurance policies, annuities, accounts that are out in securities, we set beneficiaries on all of those. And what everyone has to understand, which I think sometimes people don't, and you're going to be able to verify this for me, but if you've got a beneficiary on a life insurance policy, an annuity policy, that trumps whatever you've got in the will or the trust.
That is absolutely correct. Beneficiary designations, co-ownership, all of that trumps the will. The only thing that the will works on are assets in your name alone, without a co-owner, without a beneficiary, or not in a trust.
Or not in a trust.
Right. So basically, I own a lot in my name and I die. That my will would cover. But if I own it in my name and my husband's name, then I don't have to worry about it with the will.
Right.
My ownership designation trumps the will.
Got
So your beneficiary designations that you fill out on a daily basis greatly affect the estate plan. You probably do more estate planning on a day-to-day basis than I actually do.
Probably so, actually. I've got beneficiaries all over the place. And I always tell people, let me meet at least one of the beneficiaries and hopefully meet whoever will be your executor.
Right.
Because I don't want that first meeting to be one of someone coming in, they've just lost a parent, they're upset, they're emotional, they're going to be talking about things they probably have never done before. I want them to feel comfortable, and I would say it's the same thing with you, because they're going to come to you for probate situations. You want to know who you're going to be talking to. I just think that's an important thing. So the beneficiaries definitely trump. You've got to check them. So if I go in and my estate is pretty simple, and I do a will, I need some other documents.
Absolutely.
And those are?
Well, the will is going to cover when you die. So you're not here anymore.
Right.
More importantly, you need to cover while you're alive. So if you become incompetent, you have an accident, you have a stroke, something like that, you need somebody else to be able to handle your affairs for you. So I recommend people have a durable financial power of attorney, which is a power of attorney that survives incapacity. So somebody could pay your bills for you if need be. I recommend a healthcare directive, which is naming somebody basically as your power of attorney for healthcare.
For health.
And I also recommend that you decide whether or not you want a living will, because you don't want to be hooked up to machines, forever if you're not going to survive. So I tell people that's something to consider at the time we're doing the will.
Sure.
Now, there is another document called a do not resuscitate order, which is a document that an attorney cannot fill out with you. You have to fill that out with the doctor.
With the physician.
Right, and that's a little bit different than the living will. The living will is just telling everybody, I don't want to be hooked up to machines if there's no hope for my recovery.
Okay.
The do not resuscitate is, I have a heart attack right now. That's telling the EMTs, don't try to bring me back.
Don't try to bring me back.
Now, it's been my experience that most of my clients don't really want that, because if you or I had a heart attack right now, we'd probably want them to try to bring us back.
Definitely.
So usually those are reserved for my very elderly clients, maybe somebody who has a terminal condition, but that has to be signed by the doctor.
That's definitely. And the other thing I tell my clients, though, in fact, we had that discussion the other day with one of my clients, who do I put as my power of attorney? Be reasonable, and I'm sure, Kathleen, you'll agree with me on this. If you have a child that every 6 months is coming to you saying, Mom, I need money. I can't pay my bills. Mom, you got to pay my rent. I'm going to be evicted. Do not put that child as your power of attorney on your financial matters, because if they can't handle their money, they're not going to be able to handle yours either. You want somebody who understands money, who's frugal. On the same page, you don't want to ask someone like me to be your medical power of attorney. I get weak-kneed when I walk into a hospital. Don't ask me to make those kinds of decisions for you. I would be totally useless. So think about who you want, why you want them. Sometimes people get more than one.
Right, and they can be different too.
Yeah.
You could have the child that does come to you for the rent money, because they might be very compassionate. They might be great for healthcare decision making, just not on the financial.
Right.
So you may have another person in the family that's a little more financially savvy. They should be on the durable financial power of attorney.
Right. So think about it, and all these things, remember, as long as you are alive, they're changeable. It's when you have passed on.
Or become incapacitated.
Thank you. At that point, we can't change them. So think about it. And, I've seen this with clients. I know you have. They'll come in and, I want this son to do that. And then a year later, they come in and they don't want that son on anything, because the son maybe married somebody they didn't like, or the son has gone crazy and done stupid things, and they don't trust him anymore. So keep those documents accurate. What about, too, one of the things we hear about a lot is the HIPAA list now. That's required by the hospitals and medical.
You want to have down who can have your information.
Okay.
Because of all the privacy laws, you want to say in your health care directive that, I want them to have all the information notwithstanding the HIPAA laws. So it's very important to name that person, especially, we were talking earlier about the couple who hasn't married. They don't want to marry because it will affect their Social Security. If something happens to one of them and they have to go to the hospital, the other one's not going to be allowed in there, number one, and they're not going to be able to make decisions, number two.
Oh, how sad.
So it's so important in that situation that there's a health care directive and saying who can have information and who can't.
Who can. And one of the things I've found, too, is that sometimes people get into this situation, they think, well, we're married. I don't have to worry. My wife can come in and talk for me. My husband can come in and make medical decisions. But in today's society, we travel together an awfully lot. And we've seen it happen. One dies, the other is incapacitated for some reason, in a coma. Who's going to make the decision? Who's going to pay the bills? Who's going to do what has to be done? So don't get this sense of false security. I always tell people, even on the financial side, plan for the worst that could happen.
Right.
Not the best.
Plan for the worst and hope for the best.
Hope for the best. Hope for the best. And we know we're probably going to be somewhere in the middle.
Correct.
Because very seldom do we get the best, very seldom do we get the worst. We're usually somewhere in the middle, but if you're prepared for this, you can handle the other two without any problems whatsoever.
Right.
So the HIPAA laws we have to take into consideration, looking at the beneficiaries often, reviewing who has your power of attorney. What about minor children?
Minor children. That's a favorite one with beneficiary designations. People do not realize that they should not put beneficiary designations in the name of a minor. And it happens all the time.
Yes.
People come in and I start looking at who they have their IRA made out to. And I'm like, well, isn't this your daughter's child? Yes. Well, how old? 3. I'm like, oh my goodness. We
Yeah.
never ever want to
Can't
have a
do that.
3-year-old as the beneficiary on anything. No minor children should be beneficiaries of anything. If you in fact want that particular minor child to receive something, you need to set it up so that there's an adult as custodian for their benefit.
Yeah.
So if you wanted to be the custodian for your nephew you were just
Yes.
telling me about a little while ago,
Yes.
it would just have to say Annalee as custodian for nephew number 1.
Right.
And that would be fine, but just leaving it to nephew number 1,
Not good.
major problem. End up with a guardianship through the court system,
And you
the
don't
child,
know who that's going to be.
Well, in all likelihood, it would be a parent.
Yeah.
But the parent has to every year file an accounting with the court. They have to ask permission anytime they want to use the money. And the worst thing about that scenario is the child gets it at 18. So I have seen them get it at 18, and they usually don't have anything left at 19.
Oh, that turns into a big red shiny car real
Yes.
fast.
Yes, it does.
I mean, oh yeah, that's
Yep,
fun when you inherit
exactly.
that kind of money. Don't care about taxes. You don't care. It's just this big money that's there.
Right.
Kathleen, if you will quickly tell everybody how we can get in touch with you.
Okay. I'm an attorney at Smith Sauer D. Maria, and we're downtown in the Historic District,
Yes.
510 East Zaragoza, right across from the Barclay House. My number is 434-2761. But I do book usually 2 months in advance,
Yes, you do.
so I
Yes,
should
you
put
do.
that out there.
Yeah,
So.
and that's a good thing, because if you're that busy, that means you're good at what you do. Also, if you need to call us at my office, call 437-3127. Come in. We'd love to sit down and talk to you. If you need other services, we will gladly send you there. Have a blessed day. We'll see you soon.
Mainstay Financial Group offers advocacy and personal financial guidance in a caring environment. That's the heart of our practice. At Mainstay, we're dedicated to exemplary service and a caring relationship with our client, not with a number. Plan for the future now with Mainstay Financial Services.